think what you're saying is that even if there are some industries or some people who would face a great risk, and this might be necessary to address that risk. So in other words, if OSHA had adopted a more targeted rule, you might not be contesting that, or you would not be contesting that, that the problem here is its scope and that there's no differentiation between the risk faced by unvaccinated 22-year-olds and unvaccinated 60-year-olds, or industries. You were just talking about landscapers and people who work primarily outdoors, those and workers who work in an inside environment all day long. So is that the distinction that you're making? Like, they're not disputing what Justice Kagan said, that, you know, this is a grave danger and that in some circumstances this rule might be necessary, but just the scope of it makes it different.
That's right, Justice Barrett, but I just want to be very clear about this. Wherever that line is, this ETS is so far beyond that line. Congress identified, and even OSHA identified, for instance, certain healthcare scenarios. For instance, if you're treating COVID patients, or you're a scientist in a laboratory handling COVID samples and researching them, of course that's going to be a very different case.
Having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
And the Queen. Ah, I've heard that many times.
Justice Sotomayor is participating remotely this morning. As in this application, Mr. Flowers from Ohio will also be participating remotely. And we will hear argument first this morning in application 21A-244, National Federation of Independent Business versus the Department of Labor, and the consolidated case. Mr. Keller.
Mr. Chief Justice, and may it please the court, OSHA's economy-wide one-size-fits-all mandate covering 84 million Americans is not a necessary, indispensable use of OSHA's extraordinary emergency power, which this court has recognized is narrowly circumscribed. Just 3 days ago, the U.S. Postal Service told OSHA that this ETS's requirements are so burdensome for employers that the federal government is now seeking an exemption from its own mandate for the Postal Service. That's because OSHA's economy-wide mandate would cause permanent worker displacement rippling through our national economy, which is already experiencing labor shortages and fragile supply lines. OSHA has never before mandated vaccines or widespread testing, much less across all industries. In fact, the June healthcare COVID ETS and the 1991 bloodborne pathogen rule both rejected vaccine mandates and widespread testing, and those were even just for targeting healthcare workers. And here, OSHA's vaccine and testing mandate treats virtually all industries, workplaces, and workers the same. But even Congress's rescue plan identified high-risk workplaces, and OSHA itself here recited state data confirming that certain industries like healthcare and correction facilities are higher risk. Our nation's businesses have distributed and administered hundreds of millions of COVID vaccines to Americans. Businesses have encouraged and incentivized their employees to get vaccines, but a single federal agency tasked with occupational standards cannot commandeer businesses economy-wide into becoming de facto public health agencies. So this court should immediately stay OSHA's unprecedented ETS before Monday, when OSHA begins enforcement. I welcome the court's question.
That was a tight opening. Very good.
How are we to decide when an emergency temporary standard or emergency temporary standards are necessary? What factors do you think we should use?
Justice Thomas, I think the first factor that you would have to look at is this an indispensable or essential measure? And that necessarily would require looking at what are the alternatives available. You'd have to also look at necessary to what end, and it's to abate a grave danger, and it's for an emergency. It's in a temporary setting. So the factors you'd want to consider are, what are the risks? And not only what are the risks for any isolated situation, but compared to an everyday risk. Here, when OSHA itself has never mandated vaccines or widespread testing before, that itself, even in its 10 prior ETSs, which courts blocked almost all of the challenges to these prior ETSs, all of those are factors that would absolutely determine the scope of what OSHA could do here. In fact, in the June ETS, what OSHA said was, quote, OSHA recognizes that many states have taken action to protect employees with mandatory requirements that may not be appropriate for an ETS on a national level.
When in McCulloch versus Maryland, Chief Justice Marshall, in looking at necessary and proper, saw necessary as more expansive than that, as certainly modified by proper or in the context of proper. So it just suggests that necessary can be really necessary or not necessarily really necessary. And I just think that, you need more than to say, oh, a lot of bad things could happen to interpret what that means. Is it restrictive? Is it very firm? Is it super necessary? And if it is, why?
Justice Thomas, the reason why it would be something approaching the indispensable or essential definition of necessary here is there's a very key intra-statutory textual clue. The emergency power must be necessary. The regular power that OSHA wields has to be reasonably necessary or appropriate.
So when do we determine that? Suppose you argue also, this is the vaccine's been around quite some time. COVID has been around even longer. So the government could have had a notice and comment. So if it's susceptible to notice and comment, then how do you analyze it in that context? You can't just say, well, it's emergency, therefore it has to be absolutely necessary. It would seem that would undermine your definition or your notion of necessary.
Well, I think
Thomas
Judge
is 100%
Larson,
right.
before the Sixth Circuit, was absolutely correct in saying that just because something's temporary doesn't mean that there could somehow be more power. And what this court has said is this emergency power is narrowly circumscribed. And regardless of wherever the line would be drawn, I think this ETS is far past it. And I think the federal government has some serious line drawing problems of its own. I believe OSHA, and under the theory that's been advanced, could have shut down and had a national work lockdown at the beginning of the pandemic. I would submit that this court in Industrial Union saying that OSHA had no clear mandate in the act to have that wide of power over the American industry is also a factor that would go into this court construing what necessary means.
So the fact that it is that it's emergency sort of ups the ante, that necessary has to be more restrictive.
Yes, because of plain text, the comparison within the OSHA Act, also statutory context, major
guess,
questions.
Mr. Keller, I don't understand the point. Whatever necessary means, whether it's a necessary and proper or whether it's something more than that, why isn't this necessary to abate a grave risk? This is a pandemic in which nearly 1 million people have died. It is by far the greatest public health danger that this country has faced in the last century. More and more people are dying every day. More and more people are getting sick every day. I don't mean to be dramatic here. I'm just sort of stating facts.
Oh, you don't?
And this is the policy
I do car accidents.
that is most geared to stopping all this. There's nothing else that will perform that function better than incentivizing people strongly to vaccinate themselves.
It's a mandate.
So,
it's not an incentive.
Whatever necessary
Mandate's
means,
a kind of incentive, I guess.
whatever grave means, why isn't this necessary and grave?
Because, Justice Kagan, the standard for what would be necessary for this extraordinary use of emergency power is not what is the best way of accomplishing
It's an extraordinary use of emergency power occurring in an extraordinary circumstance. A circumstance that this country has never faced before.
Oh.
What OSHA needed to do here, though, and we do not contest that COVID is a grave danger, but when a power for it to be necessary, for instance, the Third Circuit said in wielding what is supposed to be a delicately exercised extraordinary power, the agency has to consider and explain alternatives. The agency here complained that its non-mandatory guidance wasn't being followed. And then instead of saying that maybe some of those guidances could have been made mandatory, it jumped immediately to a vaccine or testing mandate. Moreover, OSHA typically,
Mr. Carter, I guess I just don't see this as a situation, a typical arbitrary, capricious situation where we say, oh, you didn't consider an alternative carefully enough. We all know what the best policy is. I mean, by this point, 2 years later,
Do
we
we?
know that the best way to prevent spread is for people to get vaccinated, and to prevent dangerous illness and death is for people to get vaccinated. That is by far the best. The second best is to wear masks. So this is a policy that basically says we are still confronting thousands of people dying every time we look around. And so we're going to put into place the policy that we know works best, which is to strongly incentivize vaccination and to insist that unvaccinated people will wear masks and test. I mean, that's just like,
I'm going to insist on fuck you.
why isn't that necessary?
Pardon
What
my
else
English.
should be done? It's obviously the policy that's geared to preventing most sickness and death, and the agency has done everything but stand on its head to show quite clearly that no other policy will prevent sickness and death to anywhere like the degree this one will.
Justice Kagan, first of all, states could have policies like this. Private businesses could have policies like this. And even OSHA in its June healthcare COVID ETS, and that was only for healthcare workers, did not mandate vaccines. Instead, what it did there, similarly to how OSHA proceeds in many contexts, is it says, employers, give us a plan, and then if there are heightened needs in particular workplaces, then additional measures can be put into place. But this is covering economy-wide, all industries,
Well,
84
That's
million
one of
Americans.
that's one of your main objections, that this is not a workplace issue. It's a out in the world issue. Is that right?
That's right, Mr. Chief Justice.
Well, but how focused on the workplace does something have to be before you will say that OSHA can regulate it? I think, for example, of an assembly line. Workers sitting next to each other for a significant length of time, working together in close contact, that presents a different kind of risk than is typical in the outside world. So could OSHA say that for businesses with assembly lines, the workers must be vaccinated?
No, not vaccinated. OSHA, though, could potentially, going by industry or workplace by workplace, have measures such as what some of their guidance have suggested, like, potentially barriers. But I think all of this would be.
Well, but those are sort of, as Justice Kagan has been discussing, those are sort of, not as good. And why wouldn't OSHA have the authority to do the best approach possible to address what I guess you agree is a special workplace problem?
Well, Mr. Chief Justice, I don't think the standard here can be the best, because if it was the best, then that would mean that OSHA could ban all people from coming into the workplace. I think that is a power that Congress, when it
Well,
created
so the agency is acting, less aggressively than it might otherwise do, but in an effective way to address the problem.
But as soon as we get to the point where we're talking about a less aggressive way, there are other alternatives. There could have been plans. There could have been the non-mandatory
answer.
guidance that was
Nice
then put into
answer.
place. Jumping to a vaccine or testing mandate when OSHA has never exercised that
Well,
power.
there is some pressing urgency to addressing the problem, and having them sit down and say, okay, what else could we do? We have to have notice and comment, which I guess, are you insisting that be part of the process?
In this situation, yes. I mean, you have the Postal Service and Amtrak saying many employees will quit. Here, there are
Well,
reports.
just
and we
because the
have-
post office can't do it efficiently doesn't mean that private industry can't.
But I think what this shows is workplaces are different. And instead of doing an economy-wide vaccine or testing mandate for all purposes, OSHA needed to at least consider, as it identified, there are certain instances where healthcare workers and otherwise in those industries where there's a heightened risk, that's where there's a workplace occupational.
I want to ask a
Oh, God.
provisional question.
Brian.
Are you still really asking this court now, today? I mean, I assume your arguments you have good arguments in your brief, and so does the government. So I'll assume for the sake of argument that they're both fairly good arguments, okay?
Thank you.
Right. Now, that's an assumption. Right. But let's make that assumption. Are you still asking us to issue a stay and stop this from taking effect?
Yes.
Like issue a stay today or tomorrow or Sunday or Monday or Tuesday? I mean, the reason I ask that is there's several elements. We have some discretion there. And you know, it was brought up. I mean, there are 750,000 new cases yesterday. New cases, nearly 750,000, 700 and some odd thousand, okay? That's 10 times as many as when OSHA put this rule in. The hospitals are yesterday, full, almost to the point of the maximum they've ever been in this disease.
What?
Okay? And you heard references, studies. I mean, they vary, but some of them say that the hospitalization is 90% or maybe 60% or maybe 80%, but a big percent filled up yesterday or the day before
Does it make
with people
differences?
who were not vaccinated.
You're making
Okay.
shit up again,
So,
Brian.
It's hard to
Uh,
imagine
that's what we're
anything
talking
more
about
damaging
now.
to the Supreme Court's credibility
think
than
of
the
the
airing
stay
of this
requirements.
audio.
Yep.
It's both the balance of harms, it's also public interest. Can you ask us, or is that what you're doing now, to say it's in the public interest in this situation to stop this vaccination rule with nearly 1 million people? Let me not exaggerate, nearly 750,000 people. New cases every day? I mean, to me, I would find that unbelievable.
It seems that
Justice Breyer, we are asking for a stay before enforcement takes effect Monday. And the reason for that is this is an unprecedented agency action.
Yeah, I know you have all good arguments that it isn't good. They have arguments that it is
Breyer
good.
just doesn't want to do
Okay,
it.
I'm asking you a different question. And the question is, how can it conceivably be in the public interest with 750,000 people yesterday, goodness knows how many today? I don't want to repeat myself.
This
But
is
you have
not
the
an adult argument,
hospitalization
Breyer.
figures growing by factors of 10 times what it was. You have hospitalization at the record, near the record. You understand the thing as well as so I repeat my question. To me, it's unbelievable, but I want to hear what you say. How can it be in the public interest, which is a requirement? How can it be a balance of harms in this case? Assuming the arguments aren't off the wall on the government side, and believe me, they're not. Okay, that's what I want to hear the answer to.
Justice Breyer, states can act, private businesses have acted on historic levels. This is going to cause a massive economic shift in the country, billions upon billions of non-recoverable costs. Testing also is not frequently available. This is in our appendix at page 374. Among those employers who have attempted to do so, only 28% are able to find adequate providers to ensure that weekly testing is
Just because
available for
something's
the
in the public
employees.
interest doesn't mean you
If
get to mandate
Congress
people to do
intended
it.
to
Apparently it
give
does.
an
It's in the public
occupational health
interest.
agency the power to mandate vaccines across the
That's one of
country,
the
it needed to do
steps,
so
though.
clearly.
It has to be in the public
States can do
interest.
it,
So
businesses have
government
done
has
it and
to
are able to
overcome
do
that.
it. The question is not what is this country going to do about COVID, it's who gets to decide that.
Well,
Well, who
Mr.
does
Keller,
it?
maybe it's point, we can go with justice by justice. Justice Thomas, anything further? Justice Gorsuch?
I do have a couple of questions, Mr. Keller. First, the government says that the major questions doctrine and federalism canon, for example, don't apply to this court's consideration of this case or any other unless the statute before us is first found to be ambiguous. What's your understanding?
Well, 2 points. If you need to even reach the question of whether there's ambiguity, and we think the term necessary is clear in context, it has to mean indispensable or essential, that would be a term where potentially the government in their interpretation would reach ambiguity. But regardless, the major questions doctrine is also in service of avoiding non-delegation concerns. And the non-delegation concerns that this court recognized in Industrial Union and citing
I'm sorry to interrupt you, but that wasn't quite my question. I apologize if I didn't make it clear enough. But the government says that we only consult those doctrines, the federalism canon, the major questions doctrine. I think the court understands what they are, but only consults them after finding a statutory ambiguity. Do you disagree?
I disagree in that the major questions doctrine is also a doctrine that would avoid non-delegation concerns. So even if there were a clear statutory term, non-delegation concerns in how to interpret that statute would factor in. Regardless, I think the term necessary here, there's plenty of room to implement the major questions doctrine there, in addition to all of the workplace tethered languages in the plain text and statutory context.
And then secondly, I would like to understand your argument and your colleague's argument from Ohio, I believe it is, why the court should enter a stay immediately. You've asked for immediate relief. Why should the court grant immediate relief?
The short version is, as soon as businesses have to put out their plans and this takes effect, workers will quit. That itself will be a permanent worker displacement that will ripple through the national economy. So we can talk about the billions in non-recoverable costs that the government even concedes, and we can talk about the lost profits and lost goodwill and lost business reputation, and we can talk about the businesses that are going to be put out of business. Our appendix at pages 375 to 80 quotes many businesses saying this would be catastrophic. It would bankrupt our company. It would be the most devastating event our company has ever experienced. That's why we're here. We're asking for an extraordinary stay. We understand the gravity of the situation, but in balancing the sheer size and scope of this emergency power that is supposed to be exercised delicately, and the national economic implications of this when states and businesses can and have acted, we are entitled to a stay in this posture.
Justice Alito, sorry to run out of order.
No, fine. Mr. Keller, I just want to make sure I understand.
Sorry to run out of
what we
order.
should
Kagan
focus
just
on
couldn't
here.
listen for a little bit.
Is the question whether
I'm trying to listen to his argument. but-
ETS is necessary to protect the health of the general public, or is it whether it is necessary to protect just employees, and not even all employees, but only unvaccinated employees, people who have chosen independently not to be vaccinated and do not want to be vaccinated? Is that the proper focus?
Correct, the latter, Justice Alito. As OSHA has said, the grave danger here is to the unvaccinated worker who's exposed to COVID.
Thank you.
Justice Sotomayor.
Oh my God, the idiot.
She's remote. They don't have the audio.
No, I'd rather hear from Sotomayor than Breyer every day of the week and twice on
Yeah.
Sunday. I'll tell you what, man.
Although, Nate,
Let's
you're
faint
muted.
praise.
Yeah, I don't think you can just Breyer's argument is I think a simple one. It is this, everybody kind of admits this is an extraordinary measure. Even the Supreme Court in some of its past rulings admitted COVID is an extreme measure. Well, an extreme situation. So in that case, this emergency measure, it makes sense, but I don't think this guy was advocating it in the way
No,
that
Justice Sotomayor.
he wasn't
The necessary
underlying
analysis
issue here.
does have to
Didn't
account
hear
for
the question.
alternatives, but we're not asking anything close to a least restrictive
I didn't
means
hear the question. Did
analysis.
you hear the
What we're
question?
saying is the agency.
No, she's remote and it was muted.
Oh, okay. Never mind. I'm sorry. Carry on.
I'm not doing anything. This is all on their end.
Yeah, on their end.
All right.
So Sotomayor's talking. That's why we can't hear anything.
His biggest argument seems to be there's the harm to businesses, but that's I don't think that's enough to get for a win. Businesses are going to be harmed, yeah. But is that
Well, I
enough
mean,
for a win?
I don't think his argument is that, or his biggest argument is that there's harm to businesses. I think his biggest argument is that OSHA doesn't have the power to shut down the entire country, like to put a blanket thing over every industry and every workplace without going in and using particularized solutions. Is because essentially to say a federal contractor who works, in an office that's 30 feet away from everybody is not similarly situated to an assembly line worker at a chicken processing plant, right?
Mhm.
And so there are different means that could be employed that are less restrictive than this, is I think what he's going with.
But again, like we just heard that clip. He said he's not making the least restrictive means argument. So, and plus, I don't know.
He didn't use the least restrictive means argument, but he did state that he caught Roberts up in saying, well, that they could have just sent everybody home. And he's like, yeah, well, I mean, maybe they could have done that, but they didn't do that. They went with a less aggressive approach. But in doing so, the Supreme Court justices have been saying this is the best answer, but Roberts just provided a more safe answer. Just tell everybody to go home from work.
Right.
And then
I thought
Roberts
that was
seemed
a very good answer to the question.
Yeah, I think that was a good answer too.
It's like, once you go there, we win. I'm like, yeah, good answer.
I think even if you accept the agency's facts, there are now, as Your Honor just mentioned, CDC guidance contradicting foundational assumptions of the CTS. That's in our reply brief at page 7, and Your Honor just mentioned that. But regardless, even OSHA has said that 1 to 3% of employees will quit. That is significant. Our declarations, Appendix 308, 316.
Counsel, yes,
The harm
that may
argument
be
again.
true,
The
but
3%.
we are now having deaths at an unprecedented amount. Catching COVID keeps people out of the workplace for extraordinary periods of time. And there have been proof in certain industries like the medical industry that when vaccines are mandated, and there's no mandate here for a vaccine, there is a masking mandate, no different than there is when we tell people that if there are sparks flying in the workplace where workers have to wear a mask. So that's no different in my mind than this. So this is not a vaccine mandate. There are costs and deaths and other things countervailing to the fact that there might be 1 to 3% of workers who leave.
Well, and here, vaccines have been made available. I also think there's a textual clue within the OSHA Act, 29 U.S.C. 650.
You forget that there are certain states now that are stopping employers from requiring vaccines. There are certain states stopping employers from requiring masks. Why shouldn't the federal government, which it has already decided in OSHA, Congress has decided to give OSHA the power to regulate workplace safety, have a national rule that will protect workers?
Congress would have to clearly state in a statute if it wanted to give an occupational health agency the power to require employees to get certain medical treatment. It's one thing to say.
There's no requirement here. It's not a vaccine mandate. It's something totally different. And I don't know how much clearer than 651 Congress could have been. It charges OSHA with developing innovative methods, techniques, and approaches to dealing with occupational safety and health issues.
That's not a power
I
to
don't know
order.
how much clearer you can be if you're Congress to tell an agency in an emergency, do what's necessary.
That's not what those words
I
said.
don't think Congress can do it. Do you?
If Congress was going to give an occupational health agency this type of power to essentially regulate directly the employee, rather than telling employers, these are the types of things that you would want to do within your workplace, it would have had to provide that clearly. And
So what's the difference between this and telling employers where sparks are flying in the workplace, your workers have to wear a mask?
when
Well,
sparks are
it's-
flying in
a
the
mask is
workplace,
not
that's
injecting a
presumably
drug.
because there's a machine that's unique to that workplace.
But it's not a vaccine
Why
mandate.
is the
So
human
they're not
being
injecting a drug.
not
This is
like
not
a
a vaccine.
machine
It's a
if it's
testing mandate, not a
spewing
vaccine mandate.
a virus, bloodborne viruses? Are you questioning Congress's power or desire that OSHA do this? It already in 1991 told OSHA to issue regulations with respect to Hep C and B.
Justice Sotomayor, I think that exactly proves our point that Congress knows how to enact a statute when it wants to give OSHA.
It didn't enact a statute. OSHA proposed regulations. It didn't act fast enough, and Congress told it to act faster. So it wasn't Congress who proposed it. It wasn't Congress who devised it. Congress gave OSHA the responsibility to do these things, and
By
Congress
passing a
was saying,
statute?
get to it.
Yeah.
And what Congress said in there was not, you now have statutory authority to regulate all communicable diseases. It was bloodborne pathogens, and even that rule did not mandate vaccines or widespread testing.
Justice Kagan?
Part of your argument I want to come back to, because your very last sentence, you said, the question is who decides? And I think that that's right. I think that that is the question. Respectfully, I think it has a different answer than the one that you give. So I'll just sort of put a different version of it to you, which is, you know, I'm sure you're right that there are all kinds of public health and economic trade-offs that have to be made in a policy like this. All kinds of judgments on the public health side, on the economic side, how those two things ought to be balanced against each other. So who decides? Should it be the agency full of expert policymakers and completely politically accountable through the president. This is not the kind of policy in which there's no political accountability. If people like this policy, they'll go to the polls and vote it that way. If people don't like it, they'll vote that way. This is a politically
It's silly to
accountable
suggest that people
policy.
can vote on the policy.
It
They
also
have to
has
wait
the
3
virtue of
years to vote for another
expertise.
president.
So on the one
Yeah.
hand, the agency with their political leadership
disingenuous.
can decide, or on the other hand, courts can decide. Courts are not politically accountable. Courts have not been elected. Courts have no epidemiological expertise. Why in the world would courts decide this question?
What is she arguing now, that courts can't make decisions on
Congress
technically
and
complex
states
issues?
and governors
Just
wielding
she's
arguing
emergency
that she
power
shouldn't
are the
be.
ones that have the power, and we acknowledge that, over vaccines. The idea that OSHA would be the agency in the federal government that's not even under the Department of Health and Human Services, that does not have expertise over communicable diseases like the FDA or CDC maybe, that would just be a very odd place for Congress to lodge such a sweeping power over the American people.
Well, OSHA has a lot of expertise about workforces and about the dangers that workforces can confront individual employees with. And I'm sure OSHA also talked to other agencies within the federal government to consider public
just
health
knows.
issues, and brought that knowledge to bear as well with its knowledge of how workplaces function. And again, came out with a well-supported policy
Not in evidence.
that has political leadership behind it and all the political accountability that one could wish for. And why is it that courts would displace that judgment and say it is up to us to decide about vaccination policy in the employment settings of this country?
Well, first of all, what OSHA did here was not an industry by industry analysis. I mean, the line it drew, for instance, with the 100 more employee lines, they said they were doing that because they thought these larger companies were the ones that had the administrative capacity to do it. It wasn't because they were denser working environments. You could have a company with 100 employees and every single person is working somewhere else. Even the narrow exception that they have, right, that even they say that 9% of landscapers and 5% of highway workers are the only ones that would qualify for their exclusively working outside exemption. So even occupations in which you would think someone is almost exclusively working outside, they are still covered by this ETS. It's those types of internally inconsistent positions that aren't taking account of the full problem that could have been explained and should have been explained.
Thank you, Mr. Keller.
Justice Kavanaugh?
I want to follow up on Justice Kagan's who decides question, because I do think that gets to the heart of this. You're relying on the major questions canon in saying that when an agency wants to issue a major rule that resolves a major question, it can't rely on statutory language that is cryptic, vague, oblique, ambiguous. But the critique of that canon and the difficulty in applying it is figuring out when something is major enough. We've applied it 5 or 6 times in the last 40 years, and you know the cases, and they're important. We'll talk about them, I'm sure, as the argument goes on. But what should we look at to say this one is the kind of rule that rises to the level of the benzene rule or the tobacco rule that we found to be major? What should we look at?
So Alabama Realtors just said the sheer size and scope. Size would account for the overall economic impact. This covers 1.8 million establishments. The number of people affected would be another factor. This covers 84 million, or 2/3 of the private workforce. The amount of money, King versus Burwell said billions in cost, and here we have that even conceded by OSHA. The scope also. All of the 10 prior ETSs that OSHA has done, none of them have mandated vaccines. None of them have mandated widespread testing. Only one in June even dealt with COVID. The rest were all workplace toxins. And most of those challenges were upheld, most of those challenges were vindicated by the courts. And so the scope of what the agency has done before, in addition to the widespread effects, those would be the factors that you'd analyze. Also, is this a profound and earnest debate over a question of vast political and economic significance? I don't, at this point, believe that the federal government is contesting that This absolutely satisfies that.
And one follow-up question, suppose it is major enough, so accept that position for the sake of this question. Suppose the statutory language is general, broad, but doesn't speak specifically to the issue in question, but it is general and broad language. How do we sort out, so you don't necessarily say the language is ambiguous, but it also doesn't speak specifically to the issue. How would you suggest we sort out that kind of question? I realize you're going to say this language is different, but how would you sort out that kind of question?
You look at the plain text from Brown and Williamson. We know you'd also look at the statutory context. And I also think the statutory context here is incredibly important when you have the distinction between the emergency power and the regular power. This is the dialogue earlier with Justice Thomas about necessary versus reasonably necessary or appropriate. All of those textual clues, where powers have been lodged within the federal government, the fact that this isn't within the Department of Labor rather than the Department of Health and Human Services. Also King versus Burwell too on, is this the agency that has expertise over communicable diseases? No, it's not.
Do you think the agency could do this under its general power then?
No, I do not think that the agency could do an economy-wide vaccine or testing mandate across the entire economy. It has never done that even through its irregular power. It didn't do that in June in an ETS targeting healthcare workers, arguably the most heightened high-risk workplace.
Thank you.
Justice Barrett?
Mr. Keller, I want to return to the discussion you were having with both the Chief Justice and Justice Kagan earlier about whether the vaccine or test requirement is necessary to address a grave danger in the workplace. I think you would be hard-pressed to contest the Chief's point that there are some workplaces in which the danger to employees is different than that they face out in the world, a meatpacking plant or a healthcare, the dentist. And I think what you're saying, I think this is what you're saying, and I want to be sure that I understand it, that I'm correct. I think what you're saying is that even if there are some industries or some people who would face a great risk, and this might be necessary to address that risk. So in other words, if OSHA had adopted a more targeted rule, you might not be contesting that, or you would not be contesting that the problem here is its scope and that there's no differentiation between the risk faced by unvaccinated 22-year-olds and unvaccinated 60-year-olds, or industries. You were just talking about landscapers and people who work primarily outdoors, those and workers who work in an inside environment all day long. So is that the distinction that you're making? Like, they're not disputing what Justice Kagan said, that, you know, this is a grave danger and that in some circumstances this rule might be necessary, but just the scope of it makes it different.
That's right, Justice Barrett, but I just want to be very clear about this. Wherever that line is, this ETS is so far beyond that line. Congress identified and even OSHA identified, for instance, certain healthcare scenarios. For instance, if you're treating COVID patients or you're a scientist in a laboratory handling COVID samples and researching them, of course, that's going to be a very different case. But here, what OSHA did was economy-wide. It said,
well, I understand that. And you're saying that that's the problem. You're not contesting that if we were talking about healthcare workers or a meatpacking plant, you're not contesting that OSHA could rely on its emergency power to impose this kind of requirement in that context.
That's right. I would still want to know what their explanation was and all the substantial evidence. But yeah, of course, that's a very different case. And I know that's always not a satisfactory answer. But here, this ETS is so far beyond healthcare workers and what Congress identified in the rescue plan as truly high-risk workplaces.
Right. So you're saying that when we take the definition of necessary, particularly when contrasted with reasonably necessary in the general grant of authority, that it means something more, and that when we're looking at grave danger, there had to be a more targeted industry by industry analysis?
Yes.
Okay. And a follow-up, would you be here making these same arguments if this were just a masking and testing requirement and not the vaccine portion of it?
Yes, I think that mandatory testing is still a mandatory medical procedure. OSHA has never, even in a regular rule, done a blanket widespread testing regime over 84 million Americans.
What if it was just masking?
Yes.
I don't think OSHA has the ability to set by emergency rule nationwide COVID policy. The more that we back out of this and the more we say, well, if it's not an emergency rule or if it's targeted to a particular workplace, I think there can be debates about that. But as long as they're trying to set a blanket-wide, economy-wide policy by an emergency rule, OSHA does not have that power.
Thank you.
Good
Thank you,
answer.
counsel.
Gotta run for
and may
now.
it please the court.
Take
OSHA
care,
typically
Kurt.
identifies a workplace danger and then
Kurt,
regulates
you should be
it. So
signed up
here,
now. Check your
the
email.
president decided to regulate a danger and then told OSHA to find a work-related basis for doing so. This resulted in the vaccine mandate, a blunderbuss rule nationwide in scope that requires the same thing of all covered employers, regardless of the other steps they've taken to protect employees, regardless of the nature of their workplaces, regardless of their employees' risk factors, and regardless of local conditions, state and local officials are far better positioned to understand and accommodate. So sweeping a rule is not necessary to protect employees from a grave danger as the emergency provision requires. And I want to be clear, the states share OSHA's desire to bring this pandemic to a close, but the agency cannot pursue that laudable goal unlawfully. I welcome your questions.
So you're saying, Mr. Flowers, that the first step in OSHA's regulation is to identify the workforce, the problem in that workforce, and then regulate that?
That is typically how OSHA proceeds. I don't know that there's a requirement that says they must do that, but I think part of the problems we're seeing with this rule is it's not truly intended to regulate a workplace danger. It's a danger that we all face simply as a matter of waking up in the morning.
I'm sorry to interrupt you, but the other part of my question is, can a danger be so acute in the society that it is brought into the workforce and could hence be regulated by its mere presence there and by the fact that it is so acute?
I think what they need, let me answer this in two steps. I can first define what we mean by work-related danger and then talk about how that applies here. And I think that'll get to your question. So in terms of what we mean by work-related danger, I think one way to think about that is, has the employer done or failed to do something that creates a risk the employee faces? And then the problem with applying that here is if you look at their own explanation for what the risk is, this is at 61,411 of the Federal Register. They say the reason there's a risk in every workplace is you come into contact with people at the workplace. When you define the risk that broadly, that is not something that's arising out of the workplace. That's a risk we face when we wake up, when we're with our families, when we stop to get coffee on the way to work, at work, when we go to lunch, and in the evening if we go to a sporting event or a concert. So this kind of goes to Justice Barrett's question, I believe, that if they were to focus on a risk arising out of a particular aspect of the workplace that creates a risk of a different nature, like being packed closely together in a meatpacking plant, that could fairly be described as a work-related danger.
Mr. Flowers, sorry to interrupt.
Oh my God.
Do you know of any workplaces that have not fundamentally transformed themselves in the last 2 years? I mean, maybe like landscapers, they work outside. But I mean, this idea that there are only a few select
9% of them.
workplaces that are affected by COVID, I would have thought every workplace has been affected by COVID. Every workplace sent their workers home. Every workplace had to make adjustments to the way they do their
Force them
business.
to.
That's a good counter.
I'm trying to figure out like why this is a blunderbuss approach when everybody knows from living their normal lives that every workplace has been affected by this, save for, a few here and there.
They were forced to by their states.
So the way I would answer that is to
Yeah,
say
but it's not out of federal
just about
government.
every
That's what he's
workplace
saying.
has been affected,
You're right.
but
It's
that
the states,
doesn't mean
but
the
it's not
work
the
is
federal
arising
government.
from the workplace. To take another example,
The
if
point
you
is
look
they
at
Good
risk of
response.
terrorism, there's
They
some
didn't
risk of terrorism that we
voluntarily
face when we
choose
wake
to
up in
do
the
this.
morning. We face it at home, in public, and at
You
work.
can have it both ways.
And
It's
we
affecting you
adjusted
or
to
it's
that
not.
after
It's
9/11.
affecting everybody or
If
it
you see
didn't.
something, say something.
No,
Ideas like
That's
that.
what she's saying.
Now,
It's
the
if
affecting
fact
it
that
I
you face that
voluntarily
risk,
hand
that
someone
risk when you go to
$10,
work
that's
doesn't make it
different
a
than if they point
workplace
a gun
risk.
at me
It
and
means it's
make
an
me
Well,
element of
why
risk.
not? I mean, this is
think
the
so.
combination of lots of people all going in to one indoor space and having to deal with each other for 8 hours, 10 hours, however many hours a day. In those settings, the combination of the environment and the people that are in that environment create a risk, I would think. I mean, tell me if I'm wrong about this. I would think that workplace risk is about the greatest, least controllable risk with respect to COVID that any person has. Everything else a person can control. You can go to the baseball game or not go to the baseball game. You can decide who to go to the baseball game with. But you can't do any of that in workplaces. You have to be there. You have to be there for 8 hours a day. You have to be there in the exact environment that the workplace is set up with.
Do you?
And you have to be
I
there
thought
with
you
a
just
bunch
said
of
everyone
people
got
you
sent
don't
home.
know and who might be completely irresponsible. Where else do people have a greater risk than at the workplace?
Well, I think one thing with their families that they have to spend even more time with, especially if they have children going to school and things of that nature. But in response to does
she
the risk,
wouldn't know that
I
'cause
mean,
she has
of
no
course the
children.
risk arises at the workplace, but it's important to focus on the risk they're talking about. They're not talking about jobs where people do congregate in settings like that changes the nature of the risk. They say every single workplace where people come inside for even a little bit is covered. And so they've defined the risk to mean simple human contact. And it could be no more contact than you have at the grocery store, or when you drop your kids off at school, or when you go to a friend's house.
Well, Mr.
And that's
Flowers,
the problem.
in fact, what this rule does is it says we're not going to regulate some people who work outdoors, forget about it. People who work alone, we don't have to worry about them. But people who work in the way that lots and lots and lots of people work, which is surrounded by other people in indoor spaces, without their own offices,
She's
with
adding things to
cubicles
the
or
rule,
with
though.
in other mass settings. That's where the greatest risk is. Not just that's where the risk of ordinary life is. That is, in fact, where the greatest risk is.
No,
and
his
if
argument's
they had
good.
taken that approach, they would have a much better argument, but they don't, because there are many jobs here, including, for example, landscapers who may spend a little bit of time inside, 5 minutes a day to get the keys or punch their time card.
Is this right? What this says, I mean, my law clerks have been busy beavers on this case, I promise you. And what they have on this issue is that there are exceptions here. There aren't exceptions business by business, but there are exceptions, those who work from home, alone, or substantially outdoors, or those who can show that their conditions, practices, means, methods, operations, or processes make their workplaces as safe and healthful as the ETS can obtain a variance.
Can you imagine the paperwork on
So
that?
they did make some distinctions, not industry by industry. But my question really is, what I'd like to turn this to, is stay. You heard what I asked. I mean, 750 million new cases yesterday, or close to that, is
that's
a
more
lot.
people than alive.
Million.
Need to be facetious. But that's why
These are the people in charge
I
of your
would
life,
find it,
folks.
unbelievable
He misspoke.
that it could be in the public interest to suddenly stop these vaccinations.
7 billion people got
And
infected.
the
An old
only
man
answer
in a
that was
coffee
given
shop gets to
was a
misspeak
lot of
like
people
this.
will
The
quit.
Supreme Court justice hearing oral arguments ought not.
OSHA considered that. My wonderful law clerk has 61,475, 63,422, 61,466, 61,474, and 475. Those are pages. I don't think you should read all 61,000, but nonetheless, there are at least 5 or 10 pages where they went into this. And they said, in our view, yeah, that's right. Some people may quit, maybe 3%. But more may quit when they discover they have to work together with unvaccinated others, because that means
What's all this
they may get the
speculation?
disease. Okay?
On both
And
sides,
more
it's
will quit
speculatory.
because they'll be maybe die, or maybe they'll be in the hospital, or maybe they'll be sick and have to stay home for 2 weeks. So they did the pros and cons.
There's a huge difference.
So I'd like to take Justice
Huge
Kagan's
difference
questions,
between
which I think I
quitting
share on the
because other
merits,
people are sick
and
and
just
quitting
ask you,
because the
are you
government makes
asking
you.
us both still to issue a stay today, tomorrow, Monday?
Gee, he's
And
so
why?
tiresome.
We are seeking an immediate, thanks for the question. We are seeking an immediate stay. As an initial matter, I think Alabama Realtors takes their arguments about the beneficial effects of their illegal action off the table. If the court considers it illegal, then it's not in the public interest and it's proper to enjoin it. Now, the court may say, or stay it rather, the court may decide that there's a better way to unwind the illegal action than a judicial action. And I think that's what Justice Kavanaugh's concurrence in the first Alabama Realtors got to. But what it can't do is say, we judge that these are very, in our view, this illegal action will lead to good effects And so we will allow that to happen. To Justice Kagan's question about the who decides point, Congress told us who decides. The 28 U.S.C. 2112 says that courts can issue stays. And the reason for that is they recognize that this was without notice and comment. And unless the courts could step in to abate illegal actions, nobody would be able to do so. And that's especially important here, where the action they're, in our view, mandating, but at least strongly encouraging vaccination cannot be undone. Finally, the other point in the public interest is that one awkwardness of this situation is that the ETS is focused on what was really a different pandemic. It's all about the Delta variant. Now we are on to Omicron. And as my presence here as a triple vaccinated individual by phone suggests, and as Justice Sotomayor suggested, and as the amicus brief from the American Commitment Foundation shows, vaccines do not appear to be very effective in stopping the spread or transmission. They are very effective in stopping severe consequences, and that's why our states strongly urge people to get them. But I think that makes it very hard to look at the numbers they give and assume that they still apply today. Or
Counsel, those numbers show that Omicron is as deadly and causes as much serious disease in the unvaccinated as Delta did. The numbers, look at the hospitalization rates that are going on. We have more affected people in the country today than we had a year ago in January. We have hospitals that are almost at full capacity with people severely ill really on ventilators. We have over 100,000 children, which we've never had before, in serious condition, and many on ventilators.
Misinformation.
So saying it's a different variant just underscores the fact that without some workplace rules,
I want to see these 100,000 children on
with respect to vaccines or encouraging vaccines, because this is not a vaccine mandate, and requiring masking and requiring isolation of people who have tested for COVID, because none of you have addressed that part of the ETS is to say something that should be self-evident to the world, but is not, which is if you're sick, you can't come into work. The workplace can't let you into the workplace, and you shouldn't go on unmasked. Tell me what's irrational about rules of that nature when it is the workplace that puts you into contact with people that will put you at risk.
I don't know that we've argued that the requirement is irrational, and indeed, there may be many states subject to their own state laws that could impose this themselves, or private businesses. So we're not making.
So if it's within the police power to protect the health and welfare of workers, you seem to be saying the states can do it, but you're saying the federal government can't, even though it's facing the same crisis in interstate commerce.
Is this a novel legal concept
that
to her,
states are facing within their own borders?
Can't do?
I am not sure I understand the distinction. Why the states would have the power.
Is we live in a federal form of government.
Wouldn't.
Powers the states have that the federal government does not.
The federal government has no police power.
Oh, it does have power with respect to protecting the health and safety of workers. We have accept the constitutionality of OSHA.
Yes, I think you'd be asking if they had a police power to protect public health.
They have a police power to protect workers.
I would not call it a police power. I think the Commerce Clause power allows them to address health. Sorry, their question.
This is like having racial matter.
It allows them to address health in the context of the workplace.
Exactly.
It's a good time to move to our sequential questioning. Justice Thomas?
His argument is great. They're trying to solve a public health problem through OSHA rather than a workplace problem.
Seems to be
it's a great argument, but it's legally it doesn't really push
that the vaccinations are efficacious in preventing some degree of infection to others. Could you talk about that, particularly as I remember in the filings that the that the younger workers, the 20-year-olds who are unvaccinated are actually safer than the older workers who are vaccinated. So there are obviously some differences. Would you just talk about how efficacious the vaccine is in the workplace?
So first I want to be very clear. We are strong promoters of vaccination because they do stop serious illness. In terms of stopping infection and transmission, at least with the current variant, it appears, as the numbers suggest, to be far less effective. And then in terms of the comparison you were asking about, I think it's hard to define what's a grave danger in the abstract. What we can at least mandate or at least demand from the agency is internal consistency. And if you look at their own data, the CDC data from the last week of October, unvaccinated individuals 18 to 29 were as likely to die as vaccinated 50 to 64-year-olds, and 5 times less likely to die than vaccinated 65 and up. Hospitalization was between 18 and 49, that's not even just the young, was about as likely as vaccinated 65 and up. If you look at the Griffin study that they cite at 61,418 of the Federal Register, unvaccinated and vaccinated both had low risks of death in ICU. As a societal matter, we are not debating that COVID is serious. It is an incredibly grave risk for some people, not for everybody. And finally, I'd point you to the Scobie study.
That's a bad admission.
Again, they cite that 61,418 of the Federal Register says that vaccinated individuals who are 65 or older are twice as likely to die as unvaccinated individuals 18 to 49. And keep in mind that's 18 to 49, not 18 to 29. So it would probably be even more skewed if you looked at the younger demographic.
Would the state of Ohio have I'm not saying this would be an approach you would take, but you had earlier a discussion about whether or not the federal government had police powers in the workforce. And you suggested that the state has those police powers. Could the state of Ohio do what you say OSHA cannot do?
In terms of, yes, my position is the state of Ohio at least could mandate vaccinations not only for workers, but for all individuals. Now,
wow.
I think that's an important point to stress.
That's another
We're
give
talking
up.
here as though OSHA is the only entity that can regulate this, an agency that no one thought had anything to do with the pandemic until months, if not years into it. But we have the states and we have private businesses, and they're not sitting on their hands. And individuals are doing things to try and bring this pandemic to a close, or at least learn to live with it. Indeed, this court, without any requirement from OSHA, has found ways to safely conduct business.
I think my point is rather that there seems to be a suggestion that this is all or nothing, that the other governmental bodies do not have police powers to regulate certain activities. And you've answered my question. Thank you.
Justice Breyer?
Quick question. I'm just curious. I was searching for an example. Universal risk inside and outside the workplace, including the workplace. Can OSHA regulate it? Can OSHA regulate fire risks?
Yes, we don't draw the distinction between.
If they can regulate fire risks, then why can't they regulate this risk?
Because the difference with the fire is that there's something about the workplace, for example, not providing safety equipment to put out the fire.
People throw matches. They smoke sometimes. Oh, they shouldn't, but they do. Or they throw a match.
He's right though. Fire regulations from OSHA are
causes.
Universal. That kills
Such
that
as
universal.
that's like crushing people not crushing them. They come in the same room. You understand the point. Okay, the difference is
the fire.
Say it again so I catch
Yeah,
it.
but that's not the same
very clear
thing.
about this. We accept the line that's been drawn
Yeah, but
forever in
that's why you
forging
can't take
industries.
those hard lines.
Simply
There's
the
no
fact that a risk
universal.
exists outside the workplace
And then you get
doesn't mean you can't address it when it's inside the workplace. What we dispute is the idea that a risk that is ever present in all places can be regulated simply because it's also in the workplace. And so you can regulate, to be clear, OSHA could regulate COVID-19 in the workplace when the employer does something like packing individuals very closely together in a poorly ventilated area that enhances or changes the nature of the risk, I should say. But that's not the risk they say they're regulating. Again, 61,411 of the Federal Register, they say the risk is you'll come into contact with individuals, and the risk of encountering an individual is an ever-present risk we face at home, at work, and everywhere else.
Justice Alito?
I want to come back to the question I asked Mr. Keller. In light of all that's been said this morning so far about public health, about the value of vaccines to the general public, because I want to make sure I understand precisely what the question is before us. And what I took from Mr. Keller's answer, which seems to be right, is that the question is whether there is a grave danger for unvaccinated workers, period. What the secretary said was, quote, employees who are unvaccinated are in grave danger from SARS, COVID virus, but employees who are fully vaccinated are not. So if this is to be sustained, it has to be on the ground that it presents a grave danger to unvaccinated workers who have chosen to be unvaccinated. That's my understanding of the issue, but maybe I haven't understood it correctly. Is that your understanding? And I'll ask the Solicitor General the same question, or at least I hope she will address it.
That is my understanding, and I don't see how there could be another understanding, because the emergency provision specifically says that such emergency standard, meaning the precise one they issue, must be necessary to protect employees from the danger at issue. So the broad societal effects are not at issue.
And protection of vaccinated employees who may face some danger of contracting the virus was not the basis for this rule. Is that correct?
Correct. And I would go further and say they cannot rely at all on the risks of vaccinated workers, because they conclude, this is 61,419 of the Federal Register, that no one who's vaccinated is in grave danger.
Thank you.
Justice Sotomayor.
There you go. It doesn't protect all employees.
People you showed, or you pointed to young people who had a different or had the same death rate as vaccinated older people. But the point is that it's not the risk to the individual that's at question. It's that risk plus the risk to others. And unvaccinated people, and
no, that's still the risk to the
agency
individual.
has shown in its studies that unvaccinated people affect other unvaccinated people. And they vary in age and can be of ages and of conditions where the effect will be serious, if not death.
Younger people.
So we're not talking, I don't know how comparing apples to oranges in terms of the risk factors makes any sense. But secondly, if the grave risk is to unvaccinated people, then how do we take that out of the equation? That it's not the risk just to them, but the risk that they pose to others, including unvaccinated people.
That's still a risk to the unvaccinated people.
Answer in 2 steps. On the apples to oranges, I think it's vital, because they're
also, if vaccinated people can get COVID, then there's a risk to them too. So it opens the risk to everybody.
But that's not the government's position.
Are at lower risk of death and even hospitalization. That is relevant to calculation.
But lower risk doesn't mean no risk. And lower risk can go into the calculus of saying, we see, and that's what they said, the risk to unvaccinated people of all ages and all conditions. And when you remain unmasked or unvaccinated, you put yourself at risk, but you put others. Others unvaccinated people at risk, and people who are vaccinated. They may be at a lesser risk, but the grave risk remains to people of all ages and conditions that are unvaccinated.
Right. If the grave risk remains, then this isn't effective.
Numerical probabilities that are equal to be grave in one case and not grave in the other, and that is the definition of irrational. In terms of spread, their own ETS says it's unclear the degree to which vaccinations reduce transmission. They appear to have a positive effect, and they appear, at least with Delta and previous variants, to stop contracting it in the first place. So again, if you look at the American Commitment Foundation brief, it's highly doubtful that the numbers are going to be comparable when it comes to the Omicron variant.
This is tough.
Justice Kagan?
Mr. Flowers, just continuing on that, if I understand your answers to Justice Thomas and to Justice Sotomayor, you basically said a couple of things. You said, well, we understand that 18 to 29-year-olds, even though they're not going to die or wind up with very serious injuries, that they can spread. You don't doubt that those people spread to other people who might be more vulnerable. You don't doubt that, right?
That's right, but the problem.
Okay, so I'm sorry.
She doesn't want that answer.
But I just wanted to state that as like the premise. And then the question is, well, you said, well, the agency itself says that the danger is to other unvaccinated people older people, immunocompromised people, whatever. And you seem to be saying that because it's to other unvaccinated people, they assumed the risk and the agency's power runs out. Is that what you're saying? Because I don't know about that kind of doctrine in the OSHA Act or any place else in administrative law, that because you can say that, somebody would prefer not to be regulated, the agency loses its power.
That's not quite the point we're making. It goes to 2 points. The first is necessity. So if everyone who's vaccinated is not in grave danger, then a narrower solution is, if they think they have the power to vaccinate, to require the people in grave danger to be vaccinated, and they are removed from the grave danger, and the other individuals are
That's
not
a brilliant response. That
so
response was brilliant.
I think that's the key point there.
It stuck her.
Okay,
It
thank
stopped
you.
her.
Justice
Stopped her.
Gorsuch?
Yeah, it was a good response. Really good response.
Mr. Flowers, I'd like to return to the question of who decides. I think we've all kind of come to the point where we all agree that states have a wide police power under our constitutional system. But Congress has to regulate consistent with the Commerce Clause and make the major decisions, while agencies can do the work that Congress has given them to do, but not other kinds of work. And the major questions doctrine kind of regulates that interaction between Congress and agencies. So it's not that judges are supposed to decide some question of public health. It's about regulating the rules of the system to ensure that the appropriate party does. And so the question in my mind really turns a lot on the major questions doctrine in this case. Is this one that has been given to the agencies to decide, or one that Congress has to make as a major question under our federal system? And I haven't heard a lot of discussion about that. The Solicitor General says that the major questions issue only comes into play when a statute's ambiguous. I'd like to give you an opportunity to explain your view.
I think you can view the major question doctrine, the phrase is sometimes used in different contexts, and sometimes it is used as kind of an ambiguity clarifier, an elephant's and mousehole's point. But another way to look at it is something of a constitutional doubt canon, where we recognize that although our non-delegation doctrine is not especially robust today, there are limits on the amount of authority that Congress can give away. And with respect to these major questions that are going to affect people from coast to coast and cost millions and millions of dollars and potentially many jobs and potentially affect public health, we would expect Congress, we would demand Congress to at least speak clearly before we will say an agency can exercise that power, and therefore before we're into the non-delegation issue. I do want to stress a non-delegation. I mean, if they're right about work-related danger, because I understand their rule, it's any danger you could possibly face at work. A grave danger is any danger that could even conceivably result in death. Necessary means useful, and through a temporary and emergency standard, you can require permanent abatement. If you put all that together, this is among the broadest and most standardless delegations of authority to an agency in the United States Code.
Justice Kavanaugh?
They can effectively
I
shut
wanna
down
follow
every
up on
business
Justice
that
Gorsuch's
exists.
questions, which I think are important, and also Justice Kagan's questions about the policy arguments that are present here, especially in an emergency situation. So as I understand it, you're invoking the major questions doctrine and your statutory argument to say that based on the Constitution's separation of powers, Congress must act or the states must act, and OSHA lacks authority under the current statutes to do this. That's your basic pitch, I think.
Yeah,
I think so, as long as this means the vaccine mandate. We're not disputing that they can regulate COVID-19 to some degree.
Okay. Yes, that's what I meant by this. I want to give you an opportunity to explain the value of insisting on that congressional action for something like this at the federal level in an emergency situation, and explain why we shouldn't defer more to the executive or defer to the executive in what has been characterized, I think appropriately, as a crisis or an emergency kind of situation. What's
So
the
you've already
value
lost on a
of
crisis and
insisting on
emergency
that
piece.
here?
Now you're talking about the scope.
Well,
That's what the
the
argument is.
one value of it is that when there's an emergency, it's especially important that it be a considered, thoughtful process, and legislation is more likely to yield that. And in an emergency, you're more likely to get broad agreement on certain principles that can be enacted through Congress. And indeed, Congress has taken many steps to ensure that there are to address COVID-19.
Thank you.
That wasn't a great answer.
No, it's because
Thank
the
you,
reason why
counsel.
you have emergencies, you don't do legislation because of the time frame. It's